Welcome to the deep dive. I am genuinely excited that you're joining us today.
Yeah, it's great to be here.
We're tackling a topic that is, well, absolutely fundamental to criminal justice.
Definitely. But it's one that carries, significant complexities and, frankly, some serious historical baggage.
It really is. It's an area where the law has had to grapple with some incredibly powerful evidence.
And sometimes with devastating consequences when things go wrong.
Mm-hmm.
It's not always straightforward.
Exactly. And look, we want to be really clear right from the start. This entire deep dive is built only on the materials provided by the University of London.
That's right. We're incredibly grateful to them for making these valuable documents available for educational purposes.
They really offer a structured, rigorous way to understand this vital area of law.
And we're using them as our complete roadmap today.
Mm.
Think of this as a guided tour through those specific readings, cases, reports, pulling out the key insights.
Precisely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. Our mission today is to really unpack the nuances of expert evidence, drawing directly from these University of London materials.
The aim is to help you build a deep, solid understanding.
Especially if you're, preparing for exams, this is geared towards helping you navigate this topic.
We'll be exploring what it is, why it's so challenging, how the courts are supposed to handle it.
And the big questions, really, about whether the current system is truly up to the task.
And we'll definitely be highlighting key concepts and cases. We'll probably repeat them a few times.
Yeah, repetition helps. We want them to stick because getting a firm grasp on these is crucial for your understanding and, well, success.
Absolutely.
Okay, so let's set the scene. What is expert evidence actually is at its core?
Well, fundamentally, it's a really significant exception to a basic rule of evidence.
The rule against opinion evidence, right?
Exactly. Normally, a witness tells the court facts they've seen or heard, not their opinions, not their interpretations based on those facts.
But sometimes the judge or the jury, the tribunal of fact, as they're called, they just don't have the background knowledge, do they?
No. The facts might involve something technical, scientific, just outside ordinary experience.
Like interpreting complex medical reports or digital forensics.
Or engineering failures, yeah. Stuff the average person or even a judge wouldn't necessarily know about.
So in those situations, the court needs help. They need someone with that specialized knowledge or skill.
Someone who can explain things, interpret complex data, draw inferences that the tribunal of fact couldn't competently make on their own.
And that's why the exception exists. The expert's opinion is admitted to assist them.
Crucially, to assist. The expert isn't there to decide the case.
Right. They provide the understanding so the judge or jury can reach the correct verdict based on all the evidence, including the expert's input.
And importantly, it's not enough for an expert just to say, here's my conclusion.
No, they have to explain the basis of their opinion, don't they? Show they're working, essentially.
Yes, that's vital. It allows the judge or jury to see the reasoning behind the opinion.
And then decide for themselves if they accept that reasoning, if they adopt the opinion.
Exactly. The reasoning is absolutely central. An opinion without a clear basis, it's not much use to the court.
Okay, so special opinion evidence allowed to help the court understand things outside their usual knowledge, and the expert has to explain their reasoning. Got it.
But here's where it gets complicated. And this is the challenge that's really driven reform.
You mean the sheer amount of it now?
Yes. Expert evidence, particularly scientific evidence, has just exploded in courtrooms over the last few decades.
DNA, fingerprints, digital stuff.
It's everywhere.
Enormous increase. And while that's powerful, this reliance has also unfortunately shown a really bright light on the significant risks.
Risks with reliability, how it's presented. Experts may be going too far.
All of those. Issues with reliability, how complex stuff is explained or not explained. Experts may be overstating things, straying outside their actual expertise. And sadly, these issues have led to some really serious, high-profile miscarriages of justice.
They have. Which is a sobering thought, isn't it?
Yeah.
Evidence meant to find the truth actually contributing to wrongful convictions.
It really is. And that power, that potential for misuse, that's precisely why the legal system had to take a hard look at how expert evidence is handled.
This is the core problem the reform efforts have tried to tackle. How do you get the benefits while minimizing those really significant risks?
Exactly. And that risk, those miscarriages, that's the engine behind the reforms and the legal framework we're diving into today, using these University of London materials as our guide.
We've got a fair bit to get through: readings, cases, reports.
We do. So let's buckle up. And look, for all of you studying this for exams right now, you absolutely can do this. You've got this. We're sending you the very best of luck.
Good luck, everyone.
Okay, let's get properly started with section 1. What is expert evidence and why is it different? We've touched on the basics, but let's nail down these concepts using the legal materials.
Right, so fundamentally it's opinion evidence, allowed only where the judge or jury needs that specialist help to draw the right inferences from the facts.
And its purpose, always, is to assist. Not replace judgment, but inform it.
And the expert must explain the basis of that opinion so it can be properly evaluated.
Now, you mentioned the overlap between expert evidence and scientific evidence. The materials flag this up too, right? They're often used interchangeably.
Very often.
Okay.
You can see why. Think DNA, ballistics.
Hmm.
It's science, and the witness is a scientist, an expert.
Makes sense. Courts need experts to interpret scientific findings.
But it's important to remember expertise isn't only scientific. You can have experts in, say, accountancy, or art valuation, or maybe handwriting, which isn't strictly lab science.
Okay, so the line isn't always sharp. Expertise is broader than just science.
Right. And even within scientific evidence itself, there's a distinction the materials draw out.
Between fact and opinion.
Exactly. Scientific evidence often involves both. Take DNA again. The lab report says profile X found at scene. That's presented as a factual finding.
Okay, the raw result.
But then the expert explains what that profile means, how rare it is, how likely a match is, maybe how it could have got there. That's the expert's opinion based on their scientific knowledge interpreting the facts.
All right, so it's often a package deal, scientific facts, plus the expert opinion explaining their significance.
And the materials note that expert evidence is often used as a shorthand for both the facts and the opinion.
Why is that shorthand so common?
Because, crucially, often the scientific findings themselves, the raw data, the facts, would be, well, meaningless without the expert's interpretation.
They wouldn't have probative value, right? They wouldn't actually help prove or disprove anything relevant on their own.
Precisely. They need context, explanation. The materials mention Fleur and Sinichizky as an example, where raw scientific findings might just lack that essential probative value without an expert explaining what they signify in the context of the case.
So the opinion gives the facts meaning for the court.
It really breathes life into the data, which underlines why the opinion aspect is so critical, even when based on hard science.
And as we said, the amount of scientific evidence has just skyrocketed.
Hugely. It's a defining feature of modern trials.
Which brings us right back to the core problem. This massive increase, while often helpful, has definitely exposed and sort of amplified the risks involved.
Yes, risks with reliability, understanding, presentation, leading directly to those miscarriages of justice.
The wake-up call for the system. The power of the evidence demanded a rethink.
Exactly. Valuable evidence, but with serious inherent risks highlighted by past mistakes. This sets the stage for the push for reform.
Which takes us neatly into Section 2. The drive for reform, the Law Commission's proposals, those risks, those miscarriages. The system had to react.
Absolutely. It was clear the old ways weren't adequately screening evidence for reliability or making sure it was properly understood. The miscarriages were a powerful catalyst.
And the body looking into this was the Law Commission for England and Wales.
Yes, they did significant work, starting with Consultation Paper 190 back in 2009. They really dug into the challenges courts were facing, talked to lawyers, judges, scientists.
And that led to their big report.
Report number 325 in 2011. That's where they laid out their proposed solutions.
Now, the materials mention an Activity 10.1 asking why they proposed reform. Even without seeing the specific list in the report, the context we've just discussed gives the answer, doesn't it?
Pretty much. The increased use of complex, sometimes opaque evidence, the clear risks, the wrongful convictions, it all pointed to the need for better safeguards. The why is crystal clear. Prevent unreliable evidence leading people down the wrong path.
Makes sense. And the materials use fingerprint evidence as a really striking example of this changing thinking, highlighting the need to question reliability.
Ah, yes, fingerprints. For so long, treated almost as gospel. A match meant certainty.
You see it in films all the time. Got his prints. Case closed.
Exactly. Sounds definitive. But what actually emerged? through reviews in certain cases, was that experienced fingerprint experts could look at the same prints
And disagree.
and reach contradictory opinions on whether it was a match.
Wow. On fingerprints, I thought that was solid.
That was the assumption. But it proved that fingerprint comparison involves human interpretation, judgment. It's not infallible fact. It's opinion evidence, and therefore inherently fallible.
That's a massive shift. From unquestioned fact to fallible opinion must have sent ripples through the legal world.
It really did, and it powerfully showed the danger of just assuming forensic techniques are infallible. It underlined the need for courts to actively evaluate the reliability of the expert opinion, not just accept the conclusion.
Okay, so against that backdrop, exposed fallibility, risk of miscarriages, what was the Law Commission's big idea in that 2011 report?
Their headline recommendation was a new statutory test for admitting expert opinion evidence in criminal cases.
Statutory, meaning written into law, binding on judges.
Yes. The test would require the evidence to be shown to be sufficiently reliable. The idea was to put a clear mandatory legal duty on the judge to assess reliability before the jury even heard the evidence, a proper gatekeeping function enshrined in statute.
That sounds robust. Did the government go for it?
No, they rejected the recommendation for a specific statutory test of reliability.
Right, rejected the statutory test. That's key for exams. So, if not a new law, how did the Law Commission's ideas about reliability get implemented?
Well, instead of a statute, aspects of their reliability recommendations were woven into the criminal practice direction.
The CPD, that's guidance for courts, right, not primary law itself.
Exactly, guidance for judges and practitioners. First brought in around 2015, now it's in Part 7 of the Criminal Practice Directions 2023. It works alongside the common law, which still provides the basic admissibility rules.
How does the CPD incorporate the reliability stuff then? Does it make the Law Commission's test mandatory through the back door?
No, not mandatory. This is crucial. The practice direction encourages judges. It doesn't oblige them to use specific factors listed in it, particularly in paragraphs 19.8.5 and 19.8.6, to assess reliability.
And those factors are basically the Law Commission's checklist.
Pretty much, yes. They were drafted by the Law Commission as the practical criteria for assessing reliability. Paragraph 19.8.6 is especially important for scientific evidence reliability.
So the framework for checking reliability is there in the CPD, based on the Law Commission's work, but it's more like a toolkit for judges to use, especially if reliability is challenged, rather than a mandatory hurdle.
That's a good way to put it. Guidance and a checklist, not a statutory command.
And this is where the debate still lies, isn't it? Is this enough? Common law rules, plus this encouragement in the CPD, does it really manage the risks effectively without that mandatory statutory test?
Exactly that. Some argue it leaves too much discretion, isn't rigorous enough. Others say the CPD, if used properly, gives judges what they need.
It's that classic tension between flexible common law development and clear, binding statutory rules.
It is.
Okay, we've seen the drive for reform. Now let's really get into the nitty-gritty. Section 3. Admissibility, getting expert evidence into court. When is it actually allowed?
The threshold question. And the materials point out the rules differ between civil and criminal courts.
What's the rule in civil cases? More straightforward.
Generally, yes. It's governed by Part 35 of the Civil Procedure Rules. Rule 35.1 says expert evidence is restricted to what's reasonably required to resolve the proceedings.
So a test of necessity and proportionality, really. Is it genuinely needed? Is it worth the cost and time?
Pretty much. Very practical.
Okay. What about criminal cases then? Where do the rules come from?
Criminal admissibility is based on common law criteria. The Law Commission report actually summarized these quite neatly in Part 2.
And is there a key case we need to know that sets out the common law approach?
Yes, the fundamental one often cited is Luttrell. That's Luttrell, 2004 EWCA Crim 1344. Really important for understanding the baseline position.
Let's dig into Luttrell then, as the materials guide us. What was the Court of Appeals' view on admissibility in that case?
They stated what they called the proper view, which was essentially that as long as the field of expertise is sufficiently well established.
Meaning not pseudoscience or something totally new and untested.
Right. It has to be a recognized field with some basis. And if it is, then the evidence just needs to pass the ordinary tests of relevance and reliability that apply to any evidence.
Ordinary tests, so no special higher hurdle just because it's expert evidence.
That was the crucial point in Luttrell. The court rejected the idea that expert evidence automatically needs an enhanced test of admissibility, particularly regarding reliability, just because it's opinion. If it meets the normal threshold, it should, in principle, get in.
And then questions about how convincing it is, its weight, that's dealt with later.
Exactly. The weight, how much the judge or jury believes it, that's tested through the usual adversarial process. Cross-examination, opposing experts, lawyers making arguments.
That feels like the classic common law approach. Let the evidence in if it meets the basic threshold, then test it thoroughly in the trial itself.
It is, and there's a very practical point made by Thomas L.J. in Reed 2009 EWCA Crim 2698 that highlights how this works on the ground.
What did he say?
He basically noted that unless the admissibility is challenged, the judge will admit the expert evidence.
Wow. So the default is in, unless a lawyer kicks up a fuss.
Essentially, yes.
Yeah.
It puts a really heavy burden on the trial advocates, the barristers.
They have to be the ones to scrutinize the expert's basis, spot the weaknesses, and actually make a formal challenge.
Yes. The onus is on them to raise the issue of admissibility based on relevance or reliability.
That sounds like a huge responsibility, especially with really complex science.
It is. And this connects back to that concern the Law Commission raised, remember, that advocates might be hesitant to challenge experts, especially scientific ones.
Maybe because they don't feel confident with the technical stuff. Lack of training.
That was part of the concern, yes. How do you effectively cross-examine on methodology if you don't fully understand it yourself?
Yeah, it's a real barrier.
Right. And the materials suggest that getting familiar with those factors in the criminal practice direction, the 19.8.5 and 19.8.6 reliability factors, might help advocates here.
How so?
Even if they aren't scientists, those factors provide a structured checklist. They can use it to probe the methodology, the data, the reasoning. It gives them concrete points to raise in a challenge.
So the CPD acts like a practical tool for the lawyers to use when they want to challenge admissibility under the common law rules?
Exactly. It helps operationalize that reliability part of the ordinary common law test, giving specific things to look at, especially for science, via 19.8.6.
Okay, let's stick with Littrell for a moment longer, using the prompts from Activity 10.2 in the materials since it's so foundational.
Good idea. So, conditions for admission. First, the field of expertise must be sufficiently well established. Second, the evidence must pass the ordinary tests of relevance and reliability.
And the further test the defense argued for in Littrell, what was that about?
They were basically arguing for an enhanced reliability test. They thought the evidence in that case, which happened to be lip-reading evidence, was inherently risky and needed a higher bar for admissibility than just the ordinary standard.
But the Court of Appeal said no.
They disagreed that an enhanced test was automatically required just because it was expert evidence dealing with something potentially fallible. The ordinary tests were sufficient for the admissibility threshold.
So when is reliability considered then, according to Littrell?
It's always part of the ordinary admissibility test. Reliability is always relevant. The point Littrell makes is that you don't automatically apply a higher standard. But if admissibility is challenged on the grounds that the evidence isn't reliable enough even to meet the ordinary standard, then the court will look closely at reliability.
And presumably use those CPD factors now to help with that assessment.
Increasingly, yes. If challenged, the court undertakes a more focused reliability assessment.
Okay. The activity also mentions Turnbull guidelines, famous for eyewitness identification. What principle did Littrell take from cases like Turnbull?
Ah, right. Turnbull is very specific to visual ID, but Littrell drew a broader principle, the need for judicial warnings.
Warnings to the jury.
Yes. For certain types of evidence known to have inherent risks or limitations, like eyewitness ID, or like the lip-reading evidence in Littrell itself, the judge must give the jury a specific warning. They need to point out the potential pitfalls, the dangers of giving it too much weight, or misunderstanding its limits.
So it's a safeguard for potentially unreliable but still admissible evidence.
Exactly. And that leads straight to the final point from the activity. What warning does lip-reading evidence need, according to Littrell?
It needs exactly that kind of specific warning, doesn't it? The judge has to tell the jury about its inherent fallibility, its limitations, so they evaluate it carefully.
Precisely. Littrell confirms the common law stance, ordinary reliability test for admissibility, weight decided at trial, but crucially, judicial warnings for evidence types with known inherent risks.
Got it. Littrell ordinary tests plus warnings were needed.
And the materials make that nice point that those CPD factors, 19.8.5 and 19.8.6, aren't just for lawyers. They're potentially useful tools for anyone. Assessing expert claims in everyday life. Look for the basis. Check the reliability.
A good life lesson. Always ask, how do you know that? Okay, we've covered getting evidence in. Now, another fundamental test. Section 4. Relevance, the does it help test.
Right. Super important. Just because it comes from an expert, just because it might seem reliable in a vacuum, it still has to actually be relevant to the questions the court is trying to answer in this specific case.
Does it have probative value? Does it make an issue a fact the prosecution or defense needs to prove more likely or less likely?
Exactly that. If it doesn't connect to the facts in dispute, it's irrelevant. It might be interesting, but it doesn't belong in the trial.
And the materials flag a risk here, too, that courts might let in expert evidence that, sounds impressive but doesn't actually help prove anything relevant.
Yes, that's a real danger. The link between the expert finding and the case facts might be too weak. Or the expert's opinion, while valid in their field, just doesn't resolve a specific factual point the jury needs to decide. It ends up confusing things rather than clarifying.
The materials mention Barry George and Fleur and Sinichski again here in the context of relevance.
Yes, they serve as examples or reminders where the relevance, the actual probative value of expert evidence, maybe trace evidence, or specific scientific interpretations, was a key issue or concern. It shows the judge's gatekeeping role on relevance is just as vital for experts as for anyone else.
So the expert's knowledge has to be meaningfully applied to this specific dispute.
Absolutely. Doesn't matter if they're world-class. If their evidence doesn't shed light on a fact the jury needs to decide in this trial, it's irrelevant and shouldn't come in. Pertinence is key.
Okay, admissibility checked, relevance checked, but the challenges don't end there, do they? Let's move beyond admissibility, sufficiency, presentation, evaluation, and judicial directions. What happens once the evidence is actually in the trial?
Yeah, this is where we get into some really tricky practical issues and controversies. First up, sufficiency.
Meaning, can the expert evidence, maybe on its own, be enough to prove the case? Or does the prosecution need something else, some corroboration?
Exactly. And this gets particularly complex with things like DNA evidence.
Because the statistics can sound so overwhelming, 1 in a billion chance.
Precisely. It sounds incredibly powerful. Surely you might think if the defendant's DNA matches the crime scene sample with odds like that, that must be enough to establish a case to answer. Enough evidence that the defense has to respond.
But the materials say it's not that simple.
Not at all. The decision on whether DNA alone is sufficient is highly fact-specific.
Meaning it depends entirely on the circumstances, how the DNA might have got there.
Absolutely. Even DNA with an incredibly low random match probability might still need some other supporting evidence. The big question is always about innocent transfer.
How did it get there? Direct contact, secondary transfer, contamination.
All those possibilities. The court needs to be satisfied that the DNA evidence, in its specific context, points towards guilt and isn't just explained by some innocent memes.
And the materials highlight some recent cases that show this careful, fact-specific approach.
Yes, R.V. Jones, William Francis, and R.V. Killick, Shane, both from 2020, are cited as important examples. They show the Court of Appeal grappling with DNA sufficiency, especially in complex scenarios like low copy number DNA or where the transfer mechanism was disputed.
So those cases demonstrate that even mind-boggling statistics aren't an automatic win for the prosecution. The context, the expert's interpretation of how the DNA links to the events, that's crucial.
It is. And the materials suggest looking at Ward and Wardle's discussion for a deeper understanding of Jones and Killick. They help you see the principles applied in messy, real situations.
Okay, so sufficiency is context-dependent. Moving on to evaluation. Once the evidence is admitted, who decides how much weight to give it? Judge or jury?
A really critical distinction. Reed, remember, the case different from R.V. Reid clarifies this at paragraph 111. The judge evaluates the sufficiency of reliability at the admissibility stage.
Right, the judge is the gatekeeper for reliability before it gets in.
Yes, but once it's admitted, the jury takes over for the evaluation phase. Their job is to assess the weight of the expert evidence.
How convincing is it? How much do they believe it?
Exactly. They decide how much credit, how much persuasive force to give it, considering everything, the expert's basis, how they held up under cross-examination, any opposing expert evidence, and importantly, all the other evidence in the case. They do the overall assessment.
Judge, admissibility, reliability, gatekeeper, jury. Weight overall assessment. Got it. But presenting complex stuff, especially science, to a jury, that must be tough.
Notoriously difficult. The materials specifically flag the challenges with presenting DNA evidence to juries. This was famously tackled in Doheny-Adams. That's Doheny-Adams, 1997.
Doheny-Adams. That case comes up a lot with DNA, doesn't it? Feels important.
It's landmark. As the quick quiz in the materials notes, Doheny-Adams was where the Court of Appeal first gave really comprehensive guidance on interpreting DNA evidence.
What kind of guidance?
on the proper role of the expert, how they should present the evidence, and crucially, how judges should direct juries about DNA statistics to avoid common errors. Essential reading for DNA in court.
Okay, so Doheny, Adams is key for DNA presentation and direction. But the difficulties aren't just with DNA statistics, are they? What about expert opinions without a statistical basis?
No, that's a different but equally tricky set of problems. Think about an expert saying, based on my experience, this tool mark was likely made by this screwdriver. There's no validated 1 in a million statistic there.
So how does a jury evaluate that kind of experience-based, non-statistical opinion?
It's a real challenge. And cases like South, Atkins, and Lugos, that's Lugos 2013, are given as examples where the courts wrestled with this. When are these evaluative opinions admissible? How should they be presented?
And this leads to a major risk in jury evaluation, the risk of deference.
Yes, deference. The danger that the jury just mindly accepts what the expert says.
Because they seem authoritative, especially if it's labeled scientific.
Exactly. They might just defer to the expert's conclusion without critically thinking about the basis or weighing it against other evidence. They might effectively let the expert decide the issue for them, which isn't their role.
That's a serious danger. Do courts try to stop that?
They are aware of it, yes, and they're willing to step in and control the language the expert uses.
Control their choice of words?
Yes. To try and stop experts from using language that sounds more certain or definitive than the underlying basis really allows, it's an attempt to manage how the opinion is framed for the jury, to reduce the risk of undue deference. South is cited as an example of this judicial control over phrasing.
So judges can say, hang on, you can't say it's certain, maybe consistent with, or likely, to keep the jury thinking critically.
Precisely. A check on the framing.
Okay, what about the judges summing up at the end? The judicial directions. Are there special rules for expert evidence?
Well, the materials say generally no special set of rules across the board, but there are those specific warnings needed in certain areas, like the Turnbull warning for ID evidence or warnings for evidence that lacks a statistical foundation.
But the materials give that hypothetical example in activity 10.4 of a bad direction. Let's look at that. It seems like a classic mistake. The judge says something like, the DNA matches. Only 1 in a million people have this profile. You might think that makes his alibi defense pretty hard to believe.
Yes, that is a terrible direction, deeply problematic, and it highlights a fundamental error in understanding and explaining statistics.
What's wrong with it? It sounds quite persuasive, doesn't it? 1 in a million.
It sounds persuasive because it commits the prosecutor's fallacy. It wrongly equates the random match probability, the 1 in a million figure directly,
Right.
with the probability of the defendant being guilty, or the probability that his alibi is false.
The prosecutor's fallacy,
Yeah.
right? What does this statistic actually mean then?
The random match probability tells you the chance of finding that profile if you picked a random, unrelated person from the population. It does not tell you the chance the defendant is guilty.
Because the DNA could be there for other reasons. Innocent transfer, contamination, or maybe, just maybe, someone else actually matches.
Exactly. The statistic is about the frequency of the profile, not the probability of guilt in the specific case. The judge's direction is wrong because it invites the jury to jump straight from the statistic to guilt, ignoring the alibi and other possibilities.
Which is precisely what Doheny, Adams warned judges not to do.
Precisely. The judge needs to explain the statistic correctly and remind the jury they must consider all the evidence, the statistic, how the DNA might have got there, the alibi, everything before deciding.
That example really hammers home how easily this stuff can be misunderstood or misused, and why clear, correct directions are vital.
Perfect illustration of the pitfalls.
Right, before we get to the final critical evaluation, let's quickly hammer home some of those key concepts and cases again. Repetition is good for exam prep.
Definitely. First up, LCN DNA, low copy number DNA. What is it again?
Techniques for analyzing really tiny amounts of DNA, mentioned in Quiz Q2.
Good. Now, R.V. Reed, 2009. Different from Reed and Reed. What was the issue in R.V. Reed, according to Quiz Q3?
That was about how far an expert could go in giving an evaluative opinion on the likely way LCN DNA was transferred. So not just if it was there, but how it likely got there.
Correct. Which leads us nicely to Lugos 2013. Crucial case for opinions without a strict statistical basis like complex DNA mixtures or transfer opinions. What did Lugos say about admitting those, according to Quiz Q4?
Dugo said an expert can give such an opinion even without hard stats like a random match probability, but only if there's some other sufficiently reliable basis for it.
And crucially,
And the expert must make the basis of that opinion totally clear to the jury. Transparency is key so the jury understands why they reached that conclusion.
Exactly. Reliability in the foundation, transparency in the presentation, even without the big numbers. The materials note Drugos is key reading gives useful history, but also that the guidance in cases like Gugos on these non-statistical opinions remains pretty controversial.
Which is the perfect lead-in to our final section, stepping back and assessing the whole system. Okay, final section. Critical evaluation. Assessing the strengths and weaknesses of the current approach. We've journeyed through what expert evidence is, the history, the rules, the challenges. Now the big question. How well is the current system actually coping?
Yeah, we need to weigh up the tools we have, the common law from cases like Luttrell, refined over time, and particularly that criminal practice direction, Part 7, with its 19A reliability factors.
Weigh those tools against all the risks we identified. Miscarriages, complexity, jury deference, presentation issues, reliability worries, especially with non-statistical stuff.
Does the practice direction, even though it just encourages rather than obliges, actually create that new and more rigorous approach that Ward's article asks about? That's in Quiz Q5.
What's Ward's take on that?
Well, his argument, referenced in the quiz, is quite interesting. He suggests that the requirement for sufficient reliability, which is part of the admissibility test, could actually be seen as an aspect of helpfulness.
Helpfulness. How does that work?
His idea is that for an expert opinion to be genuinely helpful to the jury, it must give them sound, reliable reasons for accepting it. So if judges rigorously apply that sufficient reliability criterion, checking the basis properly,
Then that reliability check effectively ensures the evidence is helpful and trustworthy.
that's the argument. He suggests this focus on reliability as a prerequisite for helpfulness could be just as rigorous as the Law Commission's proposed statutory test, if, and it's a big if judges apply it robustly using tools like the CPD factors.
So the potential for rigor is there in the current framework, even without a statute, but it depends entirely on judicial application.
Exactly. The framework exists, but its effectiveness hinges on how it's used in practice, which links back to the controversy around cases like Lugos dealing with those non-statistical opinions.
Right. Lugos tried to give guidance, but the fact it sparked so much debate shows that area is still really difficult.
And that's where criticisms, like Roberts commenting on R.V. Reed, come in. Roberts argued the scientific basis for admitting some of those evaluative opinions, especially on DNA transfer likelihood, wasn't always clearly established in the judgments.
Leading to worries that courts might still be letting in evidence where the reliability is, well, questionable or just unknown.
That's the concern. Despite the CPD, despite the case law, is evidence of doubtful reliability still getting through the net.
So what are the main problems that still persist, do you think?
Well, there's the ongoing challenge for non-expert judges and juries trying to get their heads around highly technical stuff. The potential for expert bias or overstatement hasn't gone away. Resource inequality can the defense always afford to properly challenge prosecution experts? And the fundamental question, is the judicial gatekeeping function truly effective at stopping unreliable evidence causing miscarriages?
Which leads us to that strong critique from Edmund, mentioned in the materials, which ties right into the sample exam question.
Yes, Edmund's critique is pretty direct. He argues English courts are often too passive, too reluctant to actually exclude expert opinions, even if they seem unreliable or their probative value is murky.
Too passive. What does he think they should be doing?
He argues for more proactive gatekeeping, excluding evidence unless its reliability is clearly demonstrated before admission. He thinks judges put too much faith in the adversarial process, cross-examination, opposing experts, judicial directions, believing these can somehow fix unreliable evidence after it's already been heard by the jury.
So he thinks they overestimate the power of cross-examination and the jury's ability to sort it all out, and maybe overestimate the appeal court's ability to fix mistakes later.
Exactly. Too much faith in those formal protections and the appellate safety net, not enough rigorous screening up front. His view paints a picture of a system that's maybe a bit too laissez-faire, letting evidence in and hoping the trial process corrects flaws, rather than stopping bad evidence at the gate.
And that connects perfectly to the sample exam question's premise. The challenges are immense, we agree. The courts are equipped by law, perhaps with the CPD, Luttrell, etc. Is the main problem, therefore, the refusal of courts to use those tools effectively?
That question frames the critical analysis brilliantly. It forces you to consider the gap between the law on paper and the law in action. Is the problem the tools themselves, or the willingness or ability of judges to use them rigorously? maybe due to time pressure, lack of confidence, or just a tradition of deferring to the jury.
So for exams, it's not just knowing the rules, but critically evaluating how effectively they're applied in practice, considering these different viewpoints.
Absolutely. And it's worth stressing again, as the materials do, the problems aren't just about admissibility. Those later stage issues, sufficiency, presentation, jury evaluation, remain highly problematic and debated. They need just as much critical focus.
So the tools are there, arguably, but the debate rages on about whether they're sharp enough or used forcefully enough to guard against the dangers of unreliable expert evidence. Wow, okay. What a deep dive that was. We have covered a lot of ground.
We certainly have.
We started by defining expert evidence, the key exception needed to help the court with specialist knowledge, and straight away hit the core challenge: the boom in scientific evidence and the miscarriages that forced a rethink.
We trace the reform story. The Law Commission pushing for a statutory reliability test. The government saying no to the statute, but aspects filtering into the criminal practice direction as guidance.
We dissected admissibility under common law, focusing on Luttrell ordinary tests of relevance and reliability apply, no automatic enhanced test. We stressed the vital role of advocates challenging evidence and how the CPD factors might help them.
You looked at relevance the evidence has to actually help prove a fact and issue, recalling cases like Barry George.
And then we really got into the complexities after admission, sufficiency, especially with DNA, Jones, Killick, the distinct judge-jury roles in evaluation, Reed and Reed. The huge challenge is presenting DNA, Doheny, Adams, and non-statistical opinions, Belugo, South, Atkins.
Plus the risk of jury deference, how courts try to manage expert language, South, and the importance and pitfalls of judicial directions, remembering that prosecutor's fallacy example.
Finally, we critically evaluated the whole system. Does the current framework work? We weighed Ward's view on the potential rigor of the reliability helpfulness test against Edmonds' critique of judicial passivity and over-reliance on adversarial safeguards.
This journey has covered those key learning outcomes from the University of London materials: qualifying experts, admissibility, sufficiency, jury difficulties, directions, identifying risks, evaluating the law's response.
And hopefully equipping you to apply and critique these areas yourself. We've definitely repeated key concepts in cases: Luttrell, Doheny, Adams, Lugos, the CPD, random match probability, prosecutor's fallacy, because they are absolutely central.
You really need those locked in.
Absolutely. So, with all that swirling around, here's a final thought for you to chew on, building on that Edmund Ward debate and the exam question. Given the devastating potential of unreliable expert evidence, is our current system relying heavily on advocates to challenge and judges to apply non-binding guidance truly robust enough?
Or do we need something more fundamental, a mandatory, proactive reliability standard before evidence even reaches the jury?
Is the problem the law itself, or how it's being applied in practice day to day?
A question with massive implications for justice.
It really is. Thank you so much for joining us on this deep dive into such a critical and frankly fascinating area of law. We truly hope this detailed exploration, guided by the University of London materials, has been incredibly helpful for you.
We wish you the absolute best in your studies. And sincerest good luck for your exam. You can do this.
You've absolutely got this. Go nail it. Thanks for listening.